Hi, my name is Paul Horn. I'm a California probate attorney. I'm also a CPA. I'm here to talk to you about vesting title in your home, holding title. You're buying a house, terrific. You're in escrow. Escrow is going to give you the various options how you want to hold title to your house. There's only 8 of them. Escrow is going to ask you, do you want to hold your house as sole ownership, tenant in commons, joint tenant, community property, or community property with right of survivorship? Or do you have an LLC or corporation? Are you going to hold title? Or is it going to be in a revocable transfer and debt? Or is it in a living trust? How you hold title is really important. It has a profound effect, the legal liability and tax implication. So let's go over the 8 ways of holding title. There's only 8 ways. Let's talk about them. So if you are a single person, you're buying a house, your only option would be sole ownership. If you have a trust, put in your trust. But if you are in escrow, you're at the closing table, you're gonna close escrow, go ahead, and if you're a single person, you would hold title as sole ownership and then go ahead and transfer to your trust when you're ready, okay? Now, if you're buying a house with your, let's say, with a fellow investor, with your brother-in-law, with your uncle, you're gonna be looking at tenant in common, okay? So if you're buying a house with a business partner, tenant in commons is what you wanna do, okay? Tenant in commons means, let's say for example, if your uncle put in 80% of the money, you put in 20%, it'd be an 80-20 share. When your uncle passed away, his share will go to his children, okay? So tenant in common is for when there are more than one owners and you're not married. Go in tenant in common first, close escrow, then you can transfer to a living trust, okay? Now let's talk about joint tenant. Joint tenant happens to be the most popular way of taking title. It's the most popular for a very misunderstood reason. It's number 1 way of taking title, not because it's correct, because it's of inconvenience. So I'm here to explain and talk to you about how holding title in your home as joint tenant is a bad idea. Don't do it. Here's why. Okay? So let's say you buy a house in joint tenant. Let's do the simple one first. You buy a house in joint tenant with your friend, with a real estate investor, with a business partner. So you're buying a house with a business partner in joint tenant. You die, your share automatically go to your business partner. Too bad, so sad for your children. By definition, joint tenant, last one surviving takes it all. What I see very common and very sad, let's say for example, Jane Smith. Jane Smith is 75 years old, very wealthy, very successful. Jane Smith has a daughter from a prior marriage. Jane Smith met a man, his name is Rico Suave, he's 25 years old. Jane Smith married him, buy a house, a mansion, $5 million of her own money in joint tenant. 25 days later, happy ending for Jane. She has a smile on her face, she's in heaven. Guess who gets this house, this $5 million house? Does it go to her dear daughter, or does it go to Rico Suave, who's only been married to her for 25 days? You guessed it. By definition, joint tenant, it all goes to Rico Suave. But you say, oh my God, she's only been married to him for 25 days, and the $5 million is her money. Shouldn't go to her children, her daughter. Too bad, so sad. Joint tenant will break your heart. Okay, so that's what I call the Rico Suave situation. Be careful with that, because with a blended family, I see that happen a lot with a blended family. In a blended family, you should not do joint tenant. What I see too is this. Mom and dad owns a house. Dad passed away. Mom is getting older. Mom says, hey, I'm gonna add my son, my daughter to the grand deed, to this house. Because when I die, I want my son to have it. I want my daughter to have it. So what's the problem, right? So the house is in joint tenant. Mom died, the house goes to the daughter, to the son. Yay, right? Terrific. The problem is this. You add your son, your daughter onto your house as joint tenant, okay? If they have an IRS problem, they don't pay their taxes, they're just gonna take your house. Your house, that's right. But it's not your tax problem. Too bad, so sad, because you add your son on there, your daughter on there, their problem becomes your problem. You essentially bring their problem home with you, literally. You add your son on the grantee as joint tenant to your house. He doesn't pay his credit card debt. They sue him. Bam, they're gonna grab your house, okay? He filed bankruptcy. He's thinking in his mind, I have nothing, let me file bankruptcy. He filed bankruptcy, the United States trustee is gonna take your house because he's part owner. Do you see now the problem with joint tenant? Don't do it. Another very important reason why not to do joint tenant has to do with taxes. So let's say, as an example, you bought a house, you and your husband, you bought a house 40 years ago for $200,000. Now it's worth $2 million. Your husband passed away, right? California law, husband always die first, right? Okay, so the house is too big, right? The house is too big. The wife says, I'm gonna sell it. She sells it for $2 million, okay? Now, husband passed away. Now remember, you only bought this house for $200,000 a long time ago. Now it's worth $2 million. The wife, the surviving spouse, sells it for $2 million, okay? Now we need to figure out the capital gain. How much profit did you make from this house, right? Her husband passed away, so his half gets a step up to $1 million. The wife is still alive. They bought the house for $200,000, so her half, her cost basis is $100,000. So we calculate the capital gain. We take $2 million minus $1 million minus $100,000. Capital gain is $900,000. Capital gain is $900,000. Now, so tax problem, joint tenant, surviving spouse is gonna pay a capital gain when he or she sells his house. There's a better way to do that. Let's talk about community property. As a married couple, you can vest your home as community property. There's two types of community property or community property or survivorship. There's two types of community property, okay? So let's talk about that. Let's do community property first. Let's say you and your husband, you and your wife are buying a house, and let's say you choose community property. Just straight up, remember, there's two types of community property. One way is community property, the other way is community property with right of survivorship. Let's talk about the difference. Here's the difference. So let's say you buy a house just community property only, right? Because it's purely community property, each spouse has the right to will her half or his half away, right? So the example, let's say, the wife can will her half to the pool boy because he cleans the pool so well. That can happen, right? Because it's her half. The husband can will his half to the Laker cheerleader if he wishes, because it's his half, because it's community property, right? So let's say you have a very definitive, if you die, if you want your husband or wife to have it, then you should choose community property or right of survivorship, okay? That's the I love you way of holding title. So if you bought a house as community property right of survivorship, when you die, it automatically passes to the surviving spouse. If your husband died, it automatically passes to you. If your wife died, it automatically passes to the husband. So that's why I call it I love you way of holding title. It eliminates the quote unquote pool boy situation, okay? All right, let's talk about taxes. Remember how I said earlier, we said that joint tenant, you pay a capital gain of $900,000, but in community property, what we call the double step up in basis. Exactly the same example. You bought the house for $200,000, now it's worth $2 million. Husband died, right? The house is too big for the wife. The wife decided to sell it for $2 million. The husband's half gets stepped up to $1 million. The wife gets stepped up to $1 million as well. Hence, zero capital gain. $2 million minus $1 million, zero capital gain. Powerful, right? Powerful. So for tax reasons, vest your home as community property. If you want a built-in component of the I love you way of holding title, community property right of survivorship is the best. So the takeaway, a married couple always go with community property right of survivorship and then put it into your trust. Okay? So very, very important. As a married couple, you can do joint tenant, community property, or community property right of survivorship. Choose this one, community property with right of survivorship. So just to finish off, so if you have an LLC, a corporation, you can put your house in there too. But make sure you assign it to your trust, okay? A fairly new way of taking title is called revocable transfer and death. That came out in 2016. It's a beta test. You don't want to go revocable transfer and death because the title company is going to be very reluctant to issue good title on it for at least 3 years after mom or dad dies. So don't do revocable transfer and death. The best way to take title is in a living trust, okay? So this video explained to you when you're at the closing table, when you don't have a trust just yet, go ahead and, for example, a married couple, go ahead and do it in community property right of survivorship and then put it into your trust, okay? I have a terrific video that goes into a living trust. Just click below. It's going to take you to another video where you can watch about why a living trust is so critical to protect yourself, to protect your family, protect your children.